Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Bloomsbury Professional. It's part of the family law portfolio of books they have. It's called Family Law Arbitration, Practice and Precedents. It's now in a third edition and it's been written by Dennis Sheridan and Suzanne Kingston. This is the book here. Elizabeth was the lead writer on this work and for the review, and she gave it the title Family Law Arbitration, All You Need to Know Regarding Practice and Procedure, with a foreword by Lord Neuberger. And of course Lord Neuberger is very, very well known to many people. Charming man, very intelligent man, I met him, and in fact you do hang on the words he writes because they are really, it's a first class exposition of where we are. It's of course President of the Supreme Court. This is the book anyway, so it's a paperback. There we go. Front, then there's the spine. Then on the back you've got all the blurb. You've got the information about the two writers. They're both consultants. There's also the blurb at the bottom about Bloomsbury Professional and the online service, which we have there, which is a useful addition for many people as we move ahead into the 21st century and things start changing in a very substantial way. The back of the book is actually by page numbering. Sometimes it's by paragraph numbering, and in this case the actual referencing is by page numbers, so it's quite important to know that. And again, you've got at the back quite a lot of interesting information. You've got quite a few cases mentioned which are important. I'll get onto that in a minute. There's the front of the book there. There is the other part of it. Both of the authors are solicitors. And arbitration was an important area of family practice. I don't do much arbitration, I have to say. There's the blurb there about the book, and then there's the foreword. Always read the foreword because that sets out exactly where we are concerning the the purpose of the book and what it's actually offering. And as I say, the foreword written by Lord Neuberger. The book, as I say, Family Law Arbitration. He says, Neuberger, I strongly recommend this book. It gives user-friendly, up-to-date, full and practical guidance as to the law, rules and practice which apply to family arbitration. And it also includes a very useful set of precedents. So there we are, that's what you're getting. Then read the preface, very important, setting out what's in the book. Of course, it's a third edition, so we've had a number of previous editions. The actual preface is written by Donald Cryan, who's chairman of the advisory committee on family law. Then you've got a lot of help from contributors. I can't go through them all by name, but they're all very substantial practitioners and extremely helpful people. And that's set out as at January of this year, 2022. Then you've got a table of abbreviations. Then you've got the contents section. You can read the contents and compare and contrast it with the index, so you should be able to find what you're looking for pretty quickly. It's split into parts. Family law arbitration in practice for part 1. Part 2 is appendices. In fact, the book itself is not a particularly long book. There are a lot of appendices, including the legislation with the rules, the forms, the precedents, the case studies, which are from the people who are the contributors. They've added these particular case studies. Then there are various arbitrations, articles and cases. You can see those at the end. So this is much more of a working book as far as I see it, more than anything else. There's the table of cases there. Then you've got the table, after that, the table of statutes, which you have there. Then the statutory instruments. And then you've got part 1, which is, as I say, it's a small part, family law arbitration in practice. This is quite easy to read. You can zip through this quite quickly if you're doing this work. I think you'll find it very helpful. Arbitration and the applicable law, the financial scheme, the children's scheme, again a very important area, Children Act, arbitration forms and so forth. And then you get into the procedure. And then after that you get the actual work itself. Now the book runs to something approaching 300 pages in total. So what do we say about it? Well, money and children. These are mentioned in the foreword to this useful work of reference because they are the main types of private family law disputes. That's what I deal with. I deal with remedies, which is the money, and children, the Children Act, that's contact, and live with orders and all the other things that we have to go with that. A lot of it is not really about law, it's about managing and handling people, handling expectations. Those are, to my mind, a lot of the very basic requirements for people like myself as a senior junior, practicing in the family law bar. The difficulties for practitioners involved in such disputes are compounded by the ever-present legacy of what you might call the post-COVID era, with the resulting pressure on the courts that we've got, and not to mention the scarcity of judges and the limits on judicial time, something I'd never really come across before, I have to say. But we do have all of these problems. There's much to be said, of course, therefore, for family law arbitration, not going to court itself. When the family courts are under pressure, says Lord Neuberger, arbitration offers a very attractive alternative, and he's absolutely right. Never go to law if you can avoid it. If you can possibly get out of doing this, try to solve the problem elsewhere. I say that every time, but I'm afraid I do end up having to do these cases, and it always ends up in you say, well, who's actually won? Because they have their dirty linen washed in public, and at the end of the day, there's going to be a bit of winning and a bit of losing on both sides. And remember, with children, it's the children who suffer. That's one of the reasons why, if we can get away from the courts, it would be a marvellous step forward. But we haven't got there yet. So let me go on and say that in acrimonious disputes in which there seems to be no end in sight, arbitration then looms quite often as the only alternative to the court process. Its main advantages, of course, have been speed and complete privacy in the conduct of proceedings, although I would say courts I deal with are all secret courts, so the public aren't there, and we are generally quite expeditious, although it still takes far too long. We should be able to go to court pretty quickly and nip a few of these things in the bud, but it doesn't work quite like that. And then, therefore, for both practitioners and clients pursuing family disputes, this authoritative text is definitely what is needed. Certainly at this time. The fact is that it's now in its third edition from Bloomsbury Professional and the Family Law imprint, which we've got at the bottom, and it attests to its value, its reliability, its practicality, and its usefulness. Usefulness is what this book amply provides, in my view, because as to a large extent it may well serve to reassure certain sceptical members of the legal profession that arbitration in family law is now increasingly perceived as an authoritative and reliable process in family law disputes, largely due to the continuing and persistent work of the Institute of Family Law Arbitrators. And I understand exactly where they're coming from. The cases I deal with are where there is never going to be any dispute. You have to have a drag-out fight, and a decision is then made by the judge. But it's noted in the preface to this book that the IFLA's inception some 10 years ago, it was referred to some extent as a leap of faith, as the jurisprudential basis and procedural context were the subject of some debate. Well, sadly, that's continuing to a certain extent, but I think we are settling down, and I still believe as we move to the middle of this century, we will start looking at a much more modern approach to dealing with family matters without having this rather horrendous court structure each time to look at it. Now, with the book, as you would expect, it enumerates a number of significant and key decisions from the courts. These include the finding in Haley in 2010, and certainly the dark and sinister advent of COVID and all that's happened since the beginning of 2020 has predictably increased the level of credibility assigned to family law arbitration in an increasing number of cases. Now, as I've indicated, the law in this book is structured in two parts. Part one deals with the family law arbitration in practice, and part two, which is the larger segment, consists of the appendices, and that's where the detail is. These obviously have the forms, the precedents and the case studies, as well as actual case law and learned articles. And there are examples of, for instance, there's the article on Arbitration, a Fairer Process by Alexis Campbell, Queen's Counsel, and Suzanne Kingston. Excellent book, excellent sort of essay to read. Let me conclude by saying that all this, together with the detailed table of contents and the index, as well as extensive tables of cases, make this handy paperback volume reassuringly reliable, I think, and highly recommended as a work of reference in matters of family law arbitration, especially as it's a main resource for the International Academy of Family Lawyers. Now, the law actually is stated round about the early part of 2022 because of the case law, but the date of publication is cited as at the 31st of May 2022. There's the book again, the front, then the side, then the back. If I just open it up in the middle, I'm going to look here. These are the various schemes. This is the actual workhorse of the book. It's the actual precedents and the various other bits and pieces you have. Checklist of matters for discussion, for instance. This is family arbitration with the first meeting and directions hearing. Again, I think these are very important and useful areas for anybody, and we've got things such as the case studies. Case study 2 here, for instance, is a barrister sitting as an arbitrator, and I think that will be of interest to people such as myself practicing. I'm too old to do all of that, but I do think it's quite important for the younger people coming up who are in practice to see what is expected, so that you've got some idea of how to feel, how to have a feel for the subject. All in all, I'm very pleased with this book. I think it's a first-class contribution to family law, and it's something you should have in your Chambers library. So thank you all very much indeed for what you've produced with this excellent work. Bye-bye.